All right, good morning everybody and welcome to our CBBC webinar on IP and trademarks issues. Obviously very important with the new regulations that will come out tomorrow. Our speakers today are Tom Duke, Senior IP Liaison Officer at the British Embassy in Beijing, and Gloria Liu, who's a partner at Counsel Partners. So just before we begin, I'll go through a little bit of background of CBBC for those of you who aren't aware who we are. China Britain Business Council is the leading organisation helping UK companies grow and develop their business with China. CBBC supports British companies of all sizes and at every stage of market entry with practical in-market assistance, services, industry initiatives, as well as a membership programme offering access, seminars and significant networking. CBBC works closely with the UKTI and the FCO and has a strategic partnership with the British Chamber of Commerce in Beijing, providing corporate members with reciprocal membership. Our business-led board and professional team have extensive first-hand experience of doing business in China, and through 60 years of engagement this year, CBBC has built up exceptional connections with government and business across China. CBBC services are delivered through a network of 10 offices in the UK and 13 strategic locations across China. CBBC helps companies to network and learn from China-savvy multinationals and SMEs to understand the intricacies of doing business in China and to develop sound strategies for expanding in the fast-changing and dynamic marketplace that is modern China. So that's just a little bit of background of ourselves. You can see our coverage there both in the UK and in China. Last year we opened up offices in Changsha and Xi'an, so we are moving with the business, shall we say. All right, let's move along swiftly. This is quite an interactive webinar this morning, so we do welcome you to raise your points, ask your questions. That will be right in the area that I'm just highlighting here. So there's a little red blob. If you have any questions, just type them in there. If they're relevant and pertinent to the flow of the speaker, I'll drop them in. So I'll cut across the speaker and I'll ask them immediately. If not, save them to the end. And if there's any questions that we don't get to, I'll be happy to pass it on to the speakers afterwards, and they'll be able to get back to you. If I could just now ask you to raise your hand, that would be very helpful. So if you just, the area that I'm highlighting, just click on the raise your hand button. That will enable me to make sure that I am being heard. So let me just double check. That's very good. Yeah, I can see lots of people are raising their hand. All right, very good. Moving swiftly along. Just before we begin, CBBC has recently launched a trademark request for proposal service. This can be used to quickly and easily gain like-for-like quotes from service providers for registration of your brand. CBBC's IP team is happy to answer queries relating to translating your name and registering your brand in China. So for more information, please get in touch. So that email there is at ipr@cbbc.org. So if that is interesting for you, please feel free to contact our colleagues at ipr@cbbc.org. All right, just a quick introduction of our speakers this morning. Our first speaker, Tom Duke, has been the UK's intellectual property attaché to China since December 11, based in the embassy in Beijing. Tom is part of the UK Intellectual Property Office's International IP Attaché Network, which includes attaché postings to New Delhi, India, and Brasilia. Our second speaker today is Gloria Wu, who's a partner at Counsel, and she's also the head of the trademark department. Gloria received her law degree from Beijing Foreign Studies University School of Law in 2005. She's also received training on international finance law and intellectual property law from DePaul University College of Law in the USA. I won't go through too much as we've got to get through a lot of content today. All right, before we begin, I would just like to ask a quick poll. So I'd just like to drop in a quick poll. As I said, these are quite interactive webinars, so we like people to get involved. So if you could, you should be able to see where are you. So we're just curious to know where our listeners are today. So if you're in China or UK outside London, UK, London, or other. So I can see almost everybody has voted. We'll just give it another second or two. And we'll be having a few more of these polls just to help the speaker understand who's attending today, and also, you know, just anecdotally interesting to know what the interests of our listeners today are. So I'll close that now, and I'll just share the results with you. So as you can see from this, the majority, 75%, are in the UK outside London. As I say every time, this is very important for us. The whole point of these webinars is to give content to people who mightn't ordinarily be able to travel to a real or physical seminar that we might hold in our HQ in London. So we're delighted to welcome, delighted to welcome UK outside London. Great, so I'll hide that, and I'll hand across in that Houston, are you out there moment, trademarks in China page over to you, Tom.
Thank you very much, David. Yes, we are here. And hello, everybody. I'm Tom Duke, as David introduced, the UK's IP attaché to China, calling in here from the embassy in Beijing. My role here in this webinar, right now at least, is to give a bit of an introduction to help frame the topic. The main topic today, of course, being the revised Chinese Trademark Law, and we have Gloria here with us, who is one of the leading experts on trademarks based here in Beijing. What I would like to do before Gloria dives down into some of the detail is to set the context and give a bit of background on trademarks in China. You can see some of the statistics that are on the screen there for you. Last year, there were 1.9 million single-class trademark applications made to the Chinese Trademark Office. Note that up until tomorrow, applications are required to be in individual classes in China, although they will, as Gloria will explain, we will soon be able to see multiple class applications, so the statistics will change. But 1.9 million by any measure is a lot, and this is something very common with China, is large numbers. The UK is fairly well represented. The UK as a country uses the Chinese trademark system on a fairly sort of high volume basis. So over 7,000 of these single class applications coming in each year come from UK companies. And that puts us at around about sort of fifth in terms of the rankings of nationalities that use the system. So that sort of really displays the strength that the UK has, particularly in branding. The vast majority of the UK marks are about, for historical statistics, we're talking around about 70–75% are made directly to the CTMO, so they do only 25 to 30% use the Madrid system, and that's perhaps understandable given that many of the marks that are applied for in China will also be for Chinese language marks, which maybe don't have such an application elsewhere in the world. Another statistic that I put up there to give some background is related to one of the main issues that we hear from British companies here in the embassy. The most common problem we hear about regarding IP in China is that of people battling preemptive applications for marks that they own elsewhere in the world that they believe have been brought in bad faith. The process under the current system for that is when you detect a bad faith or preemptive registration, you can lodge an opposition with the Chinese Trademark Office, and then you can, if you're unsuccessful in that opposition, you can then appeal, and then eventually then keep appealing that through the Beijing court system. That will change, and again, Gloria will outline some of the details of that. You can also apply for cancellation of marks that are already on the register. But the key point here is that you can appeal these processes through the court system in Beijing, and the court system does release statistics. And they hear, including patent designs and trademark cases, around about 3,000 cases per year. Just over 2,000 of those are to do with trademarks. And a quite startling statistic is that around 40% of those cases are involving foreign parties. And that's quite surprising when you consider that maybe 90% of the applications for trademarks in China are by domestic residents. But the foreign parties are particularly well represented when you are appealing oppositions and cancellations through the system, which would suggest that this is indeed a problem faced by foreign parties, and perhaps also that there are some significant differences between the way the system works in China and in other countries. And again, we'll hopefully be able to highlight some of those as we go on through the webinar today. I've also listed on the screen there some of the main enforcement options that rights owners have when they come to enforce their trademark rights. You can use administrative enforcement by local government teams, typically from the local AICs, Administrations for Industry and Commerce. If you register your mark with customs, as in many other countries, you can benefit from border detentions by the China Customs. And it's worth noting here that the vast majority of interceptions by Chinese customs are for goods being exported from China elsewhere in the world. China also has a criminal enforcement system which tackles generally large-scale organized counterfeiting. Cases can be brought to the civil courts, and there are several non-official channels in which you can look to exert your rights, including things like sort of more traditional cease and desist letters based on advice from your lawyer, or using online websites, notice and takedown procedures. And again, we may touch on some of these enforcement topics, particularly where they relate to revisions in the trademark law during the rest of today's webinar. So that's my brief introduction. I hope that's helped outline sort of the context and the landscape that these changes are taking place in. I'll hand back to David now for another poll before we hear from Gloria here in Beijing.
Yeah, thanks, Tom. Thanks very much. Just a quick question. We're asking people who they are, really. We'll just give a little bit of context to help Gloria to pitch her speech a little. So, are you in-house counsel at a trademark owning company? Are you trademark attorney or lawyer, industry association, or the magic other? Which are you? So just give it another second or two. So I can see the vast majority. Let me just close that now, and I'll share that with everybody, just so we all know kind of who's online today. So 19% in-house counsel, 65% trademark attorney, 8% industry association, and only 8% for the magical other today. So that mostly we've got some trademark attorneys and lawyers. All right, I shall hand over to Gloria now. Gloria, we are now on your timeline page.
Thank you very much, David, and thank you, Tom, for your introduction and background. Hello, everyone. I'm Gloria Wu, calling from Beijing, and I'm very pleased and honored to have this chance to share with you some changes brought by the new trademark law in China. And it's also a very exciting time because tomorrow is May the 1st. It's officially the time for the new trademark law to come into effect. So perfect timing for us. So we'll start from the first slide, and just a little bit background and about the timeline issue. So when we talk about the amendment of the trademark law in China, we're not only talking about one law. It's a series of laws and regulations and Supreme Court judicial interpretation. So after the finalized version is published about the China trademark law last year in August, from the beginning of this year, we've been discussing about the draft of the implementation regulation, which is still not finalized yet. A little bit weird because tomorrow is the effective date of the new law, so we're not sure when and whether the implementation regulation will be published today or tomorrow, but we definitely look forward to seeing that. And the Supreme Court has issued an interpretation over the application of law and the jurisdiction issues related to the implementation of the new law. And the SAIC has also announced some relevant implementation regulations on the, for example, the application format and so on. And as I just mentioned, tomorrow is the effective date of the new law and the supposed to be the implementation regulation, as well as the amendment of the Supreme Court interpretation. So the first important issue we're going to discuss about is the speed of examination. I've made a chart for the comparison of the average timeline of examination in the past in contrast with the required timeline of examination according to the new law. Because in the new law, it is required that examiners should finish the examination of various types of cases within a certain timeline. So you can see from the chart that the required timeline mostly much shorter than the average timeline before. For example, for the trademark application of registration, it used to take about 14 months from filing to the publication, but now it's required to be finished within 9 months, which is quite fast. And for other cases as well, it's just getting shorter than before. So one of the advantages is that we can get faster decisions, and another is that it's more predictable for right owners or parties involved in cases like opposition and invalidation to know when we can expect a decision for the case. And the second issue, which is also not a very good news for many right owners, is about the supplementary evidence period. According to the draft of the implementation regulation, the period for submitting supplementary evidence in cases like opposition or dispute cancellation or review of recusal is shortened from 3 months to 30 days only, which is quite short. And as trademark attorneys, we have proposed to the State Council our opposition against this change, because many right owners, especially those from foreign countries, will have huge difficulty in fulfilling this kind of timeline, especially considering that many evidences from overseas need to be notarized and legalized, and such period may easily exceed maybe 30 days. So it's quite challenging, but we're not sure whether the finalized version of the implementation regulation will keep this change or follow our advice. But anyway, we need to be very prepared for that. And talking about preparation for this change, as attorneys, we strongly recommend our clients to establish and update the evidence database, especially for their important health marks and those marks which are frequently involved in cases like opposition and invalidation in future, so that evidences are categorized and updated very regularly instead of only collecting them when there's a case, because that is not a sufficient time for that to do that in future. And similarly, for the period for responding to office action is also shortened from 30 days to 15 days, according to the draft of the implementation regulations. So, for example, if the examiner requests the applicant to amend certain goods or services because they are not standard according to the Chinese classification of goods and services, the applicants now have shorter time for making a decision on how to amend the goods or services. But we have, in practice, we have other options to deal with that. If the client cannot decide before the deadline, we can submit the response to the office action maintaining the same goods and services without any amendment, and asking the examiner to issue a second office action. So just a little bit measure to deal with that, but still it's getting, we need to get more efficient and faster than before. Yeah. And opposition procedure, as Tom just mentioned, that there is some change in the procedure issues that in the past, both the opponent and opposed party can file opposition appeal to the TRAD if they're not happy with the decision. But according to the new law, only the opposed party can appeal. That the opponent cannot appeal if the opposition decision is to approve the opposed mark. So for the opponent, they can only wait until the mark is registered and then file the invalidation to the TRAD, which is a big change and will affect the strategy for many right owners, especially in dealing with like that phase or other issues in China. So for those who used to use the opposition appeal and the subsequent procedure to prolong the procedure for keep the opposed mark pending, this strategy will not work in future, because the opposition examination is shortened to only 12 months, and the opponent will not have chance to appeal. Actually, this change is very similar to the current Japanese trademark law. And just by the way, because this amendment of China trademark law this time has taken many similar points from the Japanese law. And for who can file the opposition, in the past, any party, any person can file the opposition against any published trademark. But according to the new law, only the prior right owner or the interested party can file the opposition based on relative grounds. For opposition based on absolute grounds, any person can file it. Regarding the prior right, it's not limited to only registered trademark right, but also include other types of right, like design or copyright or name right or unregistered right. So it will not affect very substantively parties who are concerning about bad faith or other issues, but only stop those who filing this kind of malicious opposition only for the purpose of stopping others, stopping like competitors' trademarks getting registered as they should. And the next issue is about bad faith. It's also a very hot topic. So in the new law, there's a new Article 7.1 saying that registration and use of trademark should follow the principle of good faith. Well, the good faith principle has always been existing in the civil law code in China, but this time the new trademark law has added into the articles in trademark law. So it's the signal is that we're putting more attention and the examiners to take into consideration of this good faith principle when they examine cases. But the a little bit problem is that in the rest articles related to the opposition ground and the invalidation ground, this Article 7.1 is not added into, is not included into the ground for filing oppositions and invalidations. So the question is that how we could use this Article 7.1 in cases, in specific cases like opposition and invalidation. Can we just base on this ground to file opposition and invalidation? According to our communication with the judges in court and the senior examiners in track, it seems that well, this principle, this good faith principle, can be cited in oppositions and invalidations. But normally, it should not be an independent ground, legal ground. It should be cited together with other legal grounds. So, but there's still use of that because examiners will, when they make decisions on their discretion, they will take more consideration of this principle. And according to our recent decisions received from Trademark Office and TRAB, we also see the trend that in many cases related to some obvious bad faith, like copying other trademarks, especially those who are not so famous in China but have some reputations in other countries. Examiners do weigh more importantly of this good faith principle. So yeah, that's a good news for many right owners actually. The next issue, that's Article 15, which is also a big improvement, I would say. In the past, in the present law, Article 15 said that agents and representatives, if without the authorization of their like client or people represented, should, if they found the application of trademarks without their authorization, such trademark can be opposed or rejected. And according to the judicial interpretation, such agent and representative includes trademark agents or representatives or sales agents or the conspiracy with those two types of people. So the scope is very limited, and the burden of proof is very heavy. We need to prove the direct connection, the relationship between the parties involved in the case and the client. So it only applies to very, very limited kinds of cases. And in many cases, when we cite this ground, the final result is that the examiner considers the evidence is not sufficient to prove such direct link. But according to the amendment, this scope is expanded to also include contractual, business, or other relationships. This other relationship really opened the door for many kinds of arguments that can be made by attorneys. For example, we can think of like neighbors or relatives of people who used to work for the client's Chinese representative. This kind of indirect relationship can be built. And of course, they also need to be based on sufficient evidence. But at least this kind of indirect relationship can also apply this article. So that is, we believe that will be very helpful for many cases we have dealt with and will deal with in future. For the next page about the well-known trademark, probably you have already heard about that. In future, well-known trademark cannot be used. The term well-known trademark cannot be used on goods or packages or containers or any advertisement or exhibition. So even if an applicant has get its trademark recognized as a well-known trademark in any trademark cases in China, they cannot use that term well-known trademark in any promotional material. The reason of having this article in the new law is that in the past there are some misunderstanding about well-known trademark in public in China, that people believe when the trademark is a well-known trademark, it has good quality and it can have honor and award given by the government, which is not true. And the lawmaker wants to change that opinion from the public and want to give the right guidance to tell the public that well-known trademark is only a case-by-case recognition of the fact and does not mean anything related to the government award. So that is the reason, yeah. And the next one is about the infringement. So for the likelihood of confusion, it's always a very interesting topic in many trademark cases. In the past, the criteria of deciding whether it constitutes trademark infringement is very simple. It's just same or similar mark used on same or similar goods. It's trademark infringement. According to the new law, there are two kinds of situations. The first kind is that the mark is same and the goods are same. So that is infringement, or we usually call it counterfeit. And the second situation is similar mark on same goods, or same mark on similar goods, or similar mark on similar goods. In this situation, we also need to decide whether there is a likelihood of confusion. And we also believe that this change is very reasonable and will be helpful in some specific cases. Yeah. When although the marks and goods are similar, but because of the nature of the goods or because of the specific kind of sales, the likelihood of confusion is very low, and in that case, no infringement would be caused. And the next issue is about the damages in infringement. In the past, the calculation of damages can be based on the profit of infringer, injury of the infringee, and plus reasonable expenses on legal actions. And the statutory damages is below 500,000 RMB. But in the amendment, apart from the original basis for calculation, we now also have appropriate multiples of trademark license fee, and we have the punitive damages, which is up to 3 times of the original damages. And the statutory damages have been raised to 3 million RMB, which is 6 times than before. That if the trademark has not been used in the past 3 years, even if infringement can be established, there's no damages ordered. So no use, no damages. And about the burden of proof, especially to prove the profit of infringer, in the past it's very, very difficult because the plaintiff, it's hard for the plaintiff to get like the accounting book or any sales record of the defendant. Those documents are held as a very confidential document of a company. And according to the new law, now the court can order the defendant to submit the accounting book and sales record to the court. If the defendant refuses to do that, or if they submit the fake one, the judge can make a decision on the amount of damages based on the claim of the plaintiff and the evidence is available. So it greatly lower the burden of proof for the plaintiff. And because of this change, and also because of the basis of damages, as I mentioned, we can foresee that there will be more and more trademark infringement cases in China with huge amounts of damages granted by the court, which is also, I think, it's a good news for right owners, and encourage more right owners to file a suit in China. and may be also helpful to stop or prevent trademark infringement issues in China. So apart from those major changes, some other changes, such as we now have sound marks, another non-traditional trademark in China. And according to the draft of the implementation regulation, in order to file the sound mark, we need to submit the sample of the sound, maybe like MP3 or CD kind of samples, together with the music note in written form. If the sound cannot be written in the form of music note, we should explain in writing like what kind of sound is that. So that's sound mark. And the second one is the multiple class application, as Tom has also mentioned, that from tomorrow, technically speaking, we can file multiple class application. And many people are interested to know whether the official fee will be changed. The Trademark Office has not announced any news about that. But according to the new format of the application form, on the back side of the application form, it mentioned the official fee, and that is the same as before. And we also confirmed with some examiners in the Trademark Office, and they say that their internal decision is that there's no change on the official fee. So, yeah, just as before. And for the division of applications, according to the draft of the implementation regulation, applicants can file division of application when they receive a partial refusal notification. And it seems from the draft that it is the only chance for the applicant to file the division of applications. It does not mention whether the applicant can file division of applications in assignment or other situations. So it is considered that probably only when there's a partial refusal, when the applicant can divide the applications to two applications. And e-filing is also mentioned in the new law.
Just reach across you there, Gloria, if I could. I've got a question here from Andrew. How many classes can be filed in a multiple class application?
Well, there's no limitation on the number of classes. So theoretically, you can file like 45 classes, every class, yeah, in one application.
All right, lovely. Thanks for that. Back to you.
Yeah. Okay. So about e-filing, yeah, we have been using the testing system of trademark e-filing system in the past years, but there is a limit of numbers of e-filing applications we can file for each law firm. But in future, right now actually, the Trademark Office is updating the system to we call it the third version of the trademark system. Which is why maybe many of you have tried to log on the China Trademark Office website, but it's not very smooth, or just cannot be open at all. So we believe that after this upgrade, the system will be better and be faster. And also, according to the draft of the implementation regulation, there will be oral hearing for trap cases. So if the trap decides that the case needs the oral hearing, or the parties request an oral hearing based on the decision of the trap, there could be one oral hearing, and parties can present their arguments and evidences during the oral hearing. I believe that could be helpful for some cases, especially when the facts involved is more complicated, or the evidences need to be explained in more detail to the examiner face-to-face. But based on our communication with many examiners, it seems that at least in a short time, there will not be many oral hearings after the new law is implemented, because the Trademark Office and the TRAP have been very busy clearing up their backlog in order to meet the timeline for examination, which is their kind of priority target right now. And the next one is about the renew. In the past, the renew can be filed 6 months before the expiration date. Now it's 12 months, so it can be filed earlier. Quite straightforward. And the last one is about the license recorder. In in the past, it is required by the trademark law that license agreement should be recorded at the trademark office, but does not mention if there are any legal consequences if the license agreement is not recorded. According to the new law, it is said that if the license agreement is not recorded, it cannot be claimed against any bona fide third party. So just clarify a little bit about the legal consequence. And yeah, I think that's everything.
Back to you, David, for the
yeah, terrific. Thanks very much, Tom. I have a quick, while we're launching the poll here, I've just got a quick question. Also, I think relates to something like with our previous question. It's from Michael. Will the current classification system with the various subclasses continue to be used?
Yes, the answer is yes. Yeah, China has been using this so-called Chinese classification of business services. So each class is divided into different subclasses, and that is the same. There's no change or mentioning of that issue in the new law.
All right.
As Gloria said, our understanding too is that the Chinese current system will be maintained, and it's worth pointing out, perhaps for people that don't have as much experience in the Chinese system, that the sort of cross-searching and the sub-classification system that China uses is in parts quite different and are often quite narrowly defined in comparison to many other jurisdictions. So it's certainly worth, if you're not familiar with that, watching out for it whenever you're needing to use the Chinese trademark system.
Terrific. Thank you for that. We have a few questions coming in, but just as we do that, we're going to launch a poll. So which areas of the revised trademark law are of most interest to you? If I could ask everybody, this again, just for interest to our speakers today. So there's a trademark application process, oppositions, cancellations, enforcement, and all of the above to an equal extent. So if you could just maybe click on which area is most relevant to you. I think that's pretty much everybody, 90% of you or so. So I'll close that. It's pretty clear, to be frank, all of the above to an equal extent. So I think from your perspective, Tom and Gloria, our listeners today are interested in all aspects of the new laws. But before we move on, I've just got a question, maybe to Gloria, I think, and it's from Xiaomu. Is it possible for a complete ban via TML 2014 regarding well-known trademark advertisement?
So just to clarify the question there, David, so I think what's being said is even the new sort of regulations now say that people who have received well-known trademark status are not allowed or not permitted to put that in advertisements or on packaging, etc. And the question, I understand it is this possible to enforce? Maybe it would be worth asking the question, how may it be enforced?
Well, because the use of the mark on the advertisement or the packages will be under the governance or the administration of AIC offices, which is the Administration of Industry and Commerce. And that office is in charge of the supervision of the market, improper behavior of companies or any business entities. So I think there will be more detailed regulations on the enforcement on this kind of ban of advertisement of well-known trademarks issued by AIC. And some of our clients have already become more nervous because some of the goods are already distributed into the market with such signs saying their market is well-known trademark. And some local AIC offices has already started like clearing up the market and giving warnings to companies or manufacturers over this kind of issue. So yes, I think we can trust that it will be enforced, and local AIC office will be the organization of the government who is in charge of enforcing this.
Yes, we have some experience that backs up Gloria's comment there too. So as I travel around China fairly often and having conversations with people working in local AICs at provincial level and sub-provincial level. Over the past sort of 6 months or so, it's been very clear that this is one of the major issues that they are focusing on in terms of preparing for life after or life under the revised Chinese trademark law. So this is, whereas all implementation and enforcement of new provisions may take a bit of time to be consistent and to be fully effective, it is something that has been on the radar of the local enforcement teams for quite a long time now. They have held a lot of internal training, so we can expect it to be taken seriously and enforced and implemented at a local level.
Terrific. Thank you for that, Tom. Sorry, Gloria. No, if you have something to add there, please do.
Yeah, sorry. There's one unclear point about this issue now is that whether retailers who sell products with this kind of well-known trademark sign on the package will also be punished. That is unclear at the moment because according to the law, it says the manufacturer or business entities should stop doing that without clarifying whether retailers, such as like Walmart or Carrefour, whether they will also be punished about that. So we'll look into that issue, and probably there will be more detailed interpretation on that.
Okay, thank you for that. I think certainly people in the China space will be very familiar with the idea of a law or a new rule coming out and everybody kind of scratching their heads for a few months until the magical implementation guidelines come along. I think that's a well-worn path for China experienced people, so I'm sure there'll be lots of new things coming out in the next few months. Tom, I think we're going to hand back to you. You have something to talk about on the implementation of the revised Chinese trademark law.
Yes, thank you, David. Although nothing more new to add necessarily, but I'm quite keen to examine some of the points that Gloria raised in a little bit more detail. And please do keep your questions coming in via the messenger system there to David, who can also supplement those into the conversation. So the slide there that is in front of you looks at some of the points, or summarizes some of the points again that Gloria raised. So maybe we can just sort of recap those and go into a little bit more detail where needed. So the first point I think I'd like to re-emphasize is relating to the examination of trademarks and the introduction into the regulations of statutory time limits for different parts of the examination process. This was, or many of these were introduced actually at the very end of quite a long revision process for the trademark law by the National People's Congress, effectively the parliament or the legislature here in China. And it caught some of the trademark authorities a little bit by surprise that these were so short and so detailed and wide-ranging. And then we did see some further statutory time limits imposed upon the applicants in subsequent regulations that came underneath the law. It's worth underlining here for the listeners, especially given that we have both in-house counsel and trademark professionals here, what the practical implications for this may be if you are making applications and dealing with the office from overseas. Gloria, I don't know if you have any thoughts about that. You maybe re-emphasize some of the points about preparation. What should people be thinking of as they are sat in the UK and they see these time limits approaching?
So I think we can talk about two parts. One is about the time limit by to the examiners. So I think at first we need to update our case diaries or case management system to change the expected timeline for each case to be finished, because that will also affect our strategies in complicated issues when cases have interdependent relationship to each other. One case may wait for decision of another case. And about that issue, about the waiting period, I think I can also add a little bit of information on that, because according to the draft of the implementation regulation, they list 6 situations where the time should not be calculated into the time limit, the statutory time limit for the examiners, which include the waiting period for the examiners. For example, if the prior right has been pending in certain other cases, and the examiners decide to wait for that case to be finished, such waiting period will not be calculated into the time limit. And also, if the parties decide to negotiate for such an agreement, and they request the examiner to suspend the case, and if the examiner agrees, such suspension time will also not be calculated in the time limit. So there are some exceptions about that time limit. And about the shortened period for submitting supplementary evidences, I think it's really very challenging, and it will affect immediately our practice for both attorneys and right owners, especially from abroad. The method to deal with that, as I mentioned, is to build up the database of evidences, which is very useful. And we have done that, in fact, many times before for clients with large amounts of evidences. But it seems that in future we need to do that for almost each client, each case.
Yeah, and this is something we see a lot of UK companies that use the system quite a lot do, is the evidence burden can sometimes be quite high, but there is a lot of repetition if you're using the system on a number of occasions. So having things prepared, well organized and ready to go will become even more important once these time limits are shortened. So I think that's certainly the first sort of major message for people to take away. Maybe, Gloria, you can mention a little bit about this sort of notarization and legalization process, because this is something I think is fairly unique to China, right?
Yes. Well, theoretically speaking, all evidences from abroad should be notarized and legalized when they are submitted to the court or the track or the trademark office in China. And that is the principle. But in practice, some types of evidences, such as trademark registration certificates in other countries, they don't need to be notarized and legalized, because usually such information can be accessed online and can be confirmed by the examiner themselves. But for other evidences from abroad, notarization and legalization is required formality requirement. And so related to that, we are still waiting for some answers from the trademark office and TRAP, that whether in some cases we can first submit a scanned copy of like a photocopy of the evidence, and before the deadline, followed up by the notarized and legalized evidences. It is still not known yet, because we are supposed to submit everything before the deadline, and any evidence submitted after the deadline will be considered as a late submission, and it will be at the examiner's discretion whether or not to consider them. And the other party can challenge the validity of such late filed evidences.
Sorry, quick question there, Gloria. If I could, I have a couple of questions to reach across. You may have answered this, but I just want to get to it. From Anne, does the opposition term remain the same, 3 months?
3 months. You mean the publication period?
I think so.
Yeah, it's 3 months.
Yeah, 3 months. Okay, fair enough. I have another question quickly here for Tom, if I could. Is the FCO preparing at all for the increase in requests for legalization?
The FCO. We don't have any sort of special measures in place for us to be required to increase our efforts. I believe that the process, though, is actually not done directly through the FCO here. It's actually the Chinese embassy in the UK. Yeah.
Okay. So well, that's probably worth clearing up for some people too as well.
Not the FCO. So don't go to Whitehall. So send your request to the Chinese government representation.
Okay.
In the that actually is quite a good transition through, actually, though, to sort of talk about some of these changes in the opposition procedures. So building from Anne's question there. This is something that we have heard quite a lot about, particularly from practitioners, but also from rights owners, and may actually cause a fundamental, or will have to cause a fundamental shift in strategies that many rights owners take. It's quite common for companies, especially those with a profile in China and business in China, to monitor the trademark register on a regular basis and pick out these applications that they want to oppose and to oppose it in a timely manner say before the mark has been granted and allowed onto the register. As Gloria said, under the new system, you can still do that. However, if you are unsuccessful in your opposition, you then do not have the right to appeal. The mark will be put onto the register, and then you will need to bring a separate cancellation action. I'm sort of wondering what Gloria's thoughts and what her clients are thinking on this at the moment. Are people reassessing their strategies? Do you think that people will still be looking to use the opposition system, or will they be looking to let marks get onto the register and then go through the cancellation system subsequently? What's your feeling on that?
Well, I think filing opposition will still be a very useful strategy for people who want to stop or try to stop other trademarks getting registered. But it's not as powerful as before. So if the opposition fails and the mark is registered, the opponent, if the opponent has been using the mark in the market in China, it will face the risk of trademark infringement immediately after the other party's mark is registered. So that is the kind of legal risk that opponents should take into consideration in their market plan in China very seriously. But in the past, they can keep the case going on for almost 10 years. Opposition appeal, and 2 instances at court. So that can last really like 10 or even longer time, 10 years or longer time. So right now it doesn't work that way, and companies who are planning to get into China's market need to consider that very seriously and need to take that legal risk into consideration.
It's worth pausing here very quickly to think about why the Chinese government has implemented these changes. There is a significant problem in China, as Gloria did touch upon briefly, with vexatious oppositions. So people making bad faith oppositions against marks when really they shouldn't. And part of the way this has been dealt with is to tighten up the regulations on who can bring oppositions. But also that's one of the motivations for this change, as they're removing the right of appeal for unsuccessful opponents. However, even though they are the underlying motivations, there are still some quite significant impacts upon British and other foreign rights owners who are typically, and in most cases that we see at least, opponents in these cases. Another point, and I completely agree with what Gloria said there about needing to reassess strategy here in terms of what may be considered to be a slightly weakened opposition option. And one of the reasons why that may be the case is that typically the China Trademark Office, the CTMO, does not produce very long and reasoned, clear decisions when they issue their decision in opposition cases. Now, the Trademark Review and Adjudication Board, TRAB, T-R-A-B, which is the appeals body, typically for CTMO decisions, or no longer in opposition, but has been in the past and will still be the appeals body in cancellation actions. The TRAB does issue much more clear, detailed, and reasoned decisions. So losing that TRAB oversight over the opposition process is one of the ways in which the opposition system will be weakened. We will see over time whether the CTMO will indeed make its decisions a little bit longer and more detailed and more robust, and that's an action which would be sort of very welcomed, I think, by many rights owners. But as the current system stands today, if the current practice is maintained and extended in the opposition process, rights owners are now potentially standing to lose some of that detail and some of that information about the reasons for the opposition decision. So again, this needs to be taken into account when people are determining their strategies, whether you're a company or a trademark attorney advising clients. Okay, so shall we sort of move on a little bit here and talk about the bad faith issue? This is something which is very, again, comes up all the time, but a very popular topic amongst British companies. Unfortunately, people who are doing business here in China. One thing to underline, I think, is this new Article 7 to make that applications need to be made in good faith. Now, technically, this principle should, I guess, have applied because it's a part of higher levels of legislation within the Chinese system. But having it into the law is potentially a strong signal, as Gloria said. And we will be watching quite closely in the coming weeks, months, and potentially years as these revisions are implemented to see exactly how this can be used. And Gloria's given some great advice here on how to use that new provision. So putting it in as an additional reason as opposed to the only grounds in an opposition or cancellation. So again, that's some quite clear initial advice. That may well evolve over time, but that's something as well I would take away as something to be building in to your strategy there. Okay, great. David, do come in if there's any further questions on these topics. I'm happy to keep going through some of the other points I have here.
Sure.
We did mention the well-known.
I've got a couple of things. Just conscious a little of time, so we're just coming up to the hour, so I don't want to go on too long. I have a couple of people have asked questions around a similar area. So to paraphrase it, I guess, are the administrative bodies that handle this sort of thing, are they changing under the new laws? So is there any sort of bureaucratic change, different offices, are they merging or changing names or anything like that? You know, perhaps there may be some new things on that side.
So there are not any changes in terms of the trademark office and the TRAB. And there are also not any new changes regarding the enforcement system, or particularly the administrative enforcement system either. Although it's worth noting that a change in the past year or so has resulted in the Chinese Food and Drug Administration taking on some of the administrative enforcement powers in terms of food safety and product safety, which has often been a route that many rights owners have taken in order to enforce against infringements related to products that could also fall under the sort of product safety rules. But the general answer to that would be no, the administrative or institutional setup will remain as it is now.
Okay, thanks for that.
I think there's one thing to mention that it's very possible that Beijing will have the IP court in near future. So we believe that is also good news for people who want to bring a case litigation in Beijing, because such court will include more experienced courts on IP issues, and yeah, it will be a good place to choose this court to settle a case.
The new IP court in China is a topic which we could talk about for a very long time. It's still not 100% clear what this will look like, and maybe that we can have a webinar on the new IP court structures, which may come in at some point in the future.
Absolutely, let's do it.
Any further questions there, David?
None that I would bring to the wider group. One or two that I might put to you to follow up. So perhaps if you want to maybe do some closing remarks or wrap it up, that would be great.
Sure. Great. So yes, I will do, David. I'd like to say thank you very much to Gloria, who's given a very clear and well-structured overview of some of the main changes. I hope that people have been able to take away some sort of key messages here that helps inform your work and strategies for your company or the companies that you advise. On one of the slides there, my email address was printed. Please do get in touch with us in the embassy here if you have any further questions or if you feel there are any sort of cases that you would like either the embassy or the China Trade and Business Council working on behalf of the British government to provide some assistance on a strategic level with. So thank you very much for joining today, and I will hand back over to David in London for the final closing remarks. Yeah,
thanks very much, Tom. Firstly, I would say thank you very much to Tom and to Gloria for their time and their expertise. Feel free to contact either CBBC or Tom directly if you need any support in this area. In terms of our webinars generally, if this is a platform that you like, please go to our website. Click on the drop-down and you'll find all of the resources for upcoming sessions and all the resources for past webinars. So that might be a recording of this, or it might be able to download the PPT. So if you've got a colleague or friend who should have seen this, then or you didn't understand it all the first time around, please feel free to log on and have a look in the future. That's really it from our side. From London, I'd say thanks very much, and I hope the new law is progressive and positive for everybody in the IP and trademark area. So thanks very much and have a great day. Bye-bye now.